Mr. Cmelik.
May it please the court. I'm here today on behalf of the commission asking this court to adopt its findings and conclusions and impose a public reprimand on the judge involved in this case, Judge Sevcik out of Black Hawk County. It seems to me in the briefing the judge has contested some of the factual findings and conclusions, but essentially admits that he committed conduct that would warrant a sanction. But he argues before this court that that sanction should be a private admonishment, something less than the sanction recommended by the commission. So with the court's indulgence, I'd like to turn first to that sanction question and whether or not it is possible for this court to issue a private reprimand in a public proceeding. I think if you look at the statutory structure and the rules here, they don't permit this court to privately admonish a judge. If you look at 602-2101, that's the enabling legislation that allows this court to remove, retire, or discipline a judge. Now, the statute doesn't define the term discipline, so at first blush it seems, well, if we have a discipline that's private admonishment, why can't this court do that? Well, the problem is then in 602-2103 that says as soon as the commission makes an application to this court, the entire case becomes public. Then you have the rules of this court, I think it's 602-1601, that says you have to issue a written opinion. That opinion, of course, is going to be public. This hearing is public. So it becomes a practical impossibility for this court to do anything in terms of its sanction that is private. By its very definition and its very nature, whatever the sanction this court imposes is going to be a public sanction. Now, the rule does seem to contemplate that the statute allows for the commission to issue a letter of warning or a letter of caution. The statutory language is actually that the commission can either dismiss a warrantless complaint, or where it's a substantiated complaint but doesn't warrant sanction, they can handle it informally. I interpret the rule then to permit a letter of caution from the commission to effectuate that statutory provision.
Is there a distinction between an admonition and a reprimand other than private or public?
I think the terminology is not all that important. You know, again, the statute doesn't define what the various disciplines that can be meted out are. And you could call it a public admonishment, but the important part of that is that it's public, not that it's private. And I think there's a reason why the statute does that. If it's a minor thing that the commission thinks can be handled informally, then it will be handled informally, and we don't risk any public perception that we're having some kind of star chamber protecting judges. However, once the commission thinks that it's important enough to apply to this court, then we're going to put it out in the open. We're going to let the public see how the process works and understand that we take these assertions seriously. Now, you always have the possibility that you could...
And that's fine. I understand the statutory limitations, but you know, we just had a case that came out that went through the entire process just like this. It was, you know, a grievance commission finding and a recommendation and an appeal to us, of course, because it's attorney discipline. We go through, had oral arguments on that as well. It's all public, and then when we got down to it, then it becomes either we can dismiss it, we still have an opinion, or have a private, or make it more private, and we protect the rights of the individual who's involved, and it does become closed, I guess I'll call it that way. Why can't a similar process be utilized here?
Well, and frankly, Your Honor, that occurred to me when I read the decision last Friday when it came down, and it referred to the attorney as John Doe. And I think the important distinction is that the rules for professional responsibility specifically provide for a John Doe proceeding in this court. I think it's Rule 3512 sub 3 specifically provides for that process. This statute and these rules do not provide for that process. So I think that that's a legislatively express provision that, or I guess in its absence, that they didn't want that kind of practice when we're talking about public officials and public appearance and the appearance of impropriety. So that's the answer that I would have. Again, you know, the statute creates the authority in this court, and I think it's important that that kind of provision that's provided in Rule 35 just isn't present here.
Do we have a choice to do a public admonishment as opposed to a public reprimand? I'm looking at our decision in Ray Kroll, a magistrate in a similar position. He, you know, it's kind of too late for a private admonition. Here we are with the cameras on. But we described it as something less than a reprimand, less serious, although in a footnote we noted we've never imposed it in judicial discipline.
Yeah. I think that that's an important concept. As I said, the statute doesn't tell this court what kind of discipline it should mete out. I suppose the idea of a reprimand versus an admonishment has developed in the common law as something that can be distinguished from one another. I think in this context, you certainly could issue an admonishment. The statute doesn't preclude you from doing so. But the important question becomes, is it public? And I think that that's the point. And I think for judges, the desire is not to have a public admonishment or reprimand if it's a minor occurrence, that it can be handled without that kind of public shame, for lack of a better word. But I don't think that a public admonishment versus a public reprimand is that distinguishable by the public and makes that much difference. But I would certainly not say this court couldn't issue a public admonishment, because the statute doesn't define what discipline this court can mete out. So I think at this particular point, looking at that statutory structure, looking at the rules, as I've suggested, this court can call the sanction anything it wants to call it. It can be a suspension, it can be an admonishment, it can be a reprimand, it can be a public letter of caution if one wanted to use that particular phrase. But the important part that it is that it is public. So I would urge this court to simply adopt the recommendation.
As I read the statute, it says that the commission submits an application to the Supreme Court to retire, discipline, or remove a judicial officer, to discipline or remove an employee. The commission shall promptly file in the Supreme Court a transcript and the other things. But where does it say it's public?
Well, I think it's 602-2104, 2103, excuse me, says, for any case which requires an application to this court, the application, all papers, all records, then become public documents. So it's separate from the rules. It's in the actual statute itself. And I think that does make it, for some judges, unfortunately, public. But I think that's a price that the legislature was willing to pay for the important policy things that are being forwarded here. So I would suggest that what the commission has done here is certainly within contemplation of the statute and certainly with contemplation of the rules. So I would urge that you simply adopt their recommendation, because I think it's supported by the record and it's supported by the findings that the court entered.
Let me, Mr. Cmelik, let me, I don't dispute that there was some violation, and I don't think Magistrate Judge Sevcik disputes that either. But it does seem to me there's maybe a little bit of overcharging here. I mean, I don't understand how a person could be violating 5111, which means by obtaining the expunged record in his capacity as an attorney, and then also violating 5135, which is misuse of information obtained in a judicial capacity. I mean, it was obtained in one or the other. I think it was obtained in the capacity of an attorney.
Yeah,
so don't we have to kind of throw out some of this stuff?
Well, that occurred to me as well, and I think ultimately it makes no difference for the sanction, but I think it is important teaching tool for this court to define what those rules mean. And I would say to you that the only cases I could find that defined in the judicial capacity are the Dodd case out of California and the Worthing case out of Utah. And they both provide a kind of an objective test that can be applied, or at least factors that can be considered when deciding whether the judge was acting in his official capacity. So I'd submit to you in this case, if you look at that framework, what we have is a judge in the courthouse during normal hours of business requesting something that only a judge can request to view. And so objectively, he is doing something that requires a judicial capacity. That makes it an act in his judicial capacity. But that doesn't mean that if it's used for an improper purpose, in the private practice, that he also then hasn't complied with Rule 51.1. I mean, I think there's a bit of an inconsistency there, but it's not a
Then
critical.
we also add on 51.13, abusing the prestige. It strikes me that the clerk didn't give the file to him because of his prestige. It gave him the file because he was a magistrate. I mean, that seems to me also kind of a difference.
Well, I think, to me, those are the same thing. It's the prestige of the office that causes the clerk not to question what's being done, even though she knows he may wear two hats. She doesn't believe that she can question him in his official capacity. Why are you asking for those particular records? So I think it does bring in the prestige of the office. It is abusing the prestige of the office, at least from a viewer's point of view. Maybe not subjectively in the judge's mind, but from any casual observer, they would have to conclude he's receiving something that he wouldn't be able to receive but for his office.
Yeah, but that would be my point. I mean, he's abusing the office, not necessarily the prestige. I mean, it always strikes me that the prestige violation, that's meant to deal with a situation where, say, the judge is dealing with some third party, where there's no question that the information would not be something, or the outcome would not be something the judge is entitled to just because the judge is a judge, and yet the person is intimidated or influenced because of the fact that the person is a judge.
Yeah. I suppose it comes down to a question as to whether we define prestige independently as something apart from the office itself, and therefore some other act has to be committed that violates the prestige, rather than just seeing prestige of office as a kind of a term of art that requires that any time an action, violates the appearance of impropriety or violates the constraints of the office, you are by definition affecting the prestige of the office.
My assumption is these things were drafted with care, and that they're not just three different ways of saying the same thing, I guess.
Well, I think that's a fair comment, but what I think is that the prestige of the office is rolled up in the notion that you have the office, and the things that you do within the office should support a kind of casual observer's viewpoint that what's being done is appropriate under the rules and under the statutes. So that's what I would offer for that particular purpose. But even if this court were to find that one or two of these particular rules weren't violated, there is at least a question here that this created an appearance of impropriety and shouldn't have been done, and the sanction would be appropriate. So I do ask the court to adopt the recommendation of the commission.
Do you agree that the magistrate was unaware when he asked for the files that have been expunged that an attorney couldn't get those files from the clerk?
I have no reason to question his veracity there. The commission didn't seem to question that. My only assertion, and I will apologize to the court and the judge both, Farmer may not directly support that proposition, but there is a wealth of case law in this state that says deferred judgments that are past their probationary period are not available for impeachment. And I think it's incumbent on all of us to know those rules and to understand how they're utilized. Thank you.
Thank you as well. Mr. Sevcik.
Thank you. May it please the court, counsel. I have a very limited appellate practice, perhaps a case every 2 or 3 years, and I've appeared before this specific court on 2 prior occasions, and the Court of Appeals on less than a dozen occasions. On each of those occasions, I was somewhat nervous, but very proud to appear and seek justice on behalf of my client. I considered it an honor and, quite frankly, be one of the high points of my legal career. This morning is quite different, and I'm quite glad I was not here last night. Rather than justice for a client, I appear before you in an action to discuss my ethical violations. The pride has been replaced with shame. Shame for my actions, for my failure to recognize those policies for which I should have known and for which I should have complied with, and shame for the time and efforts that my actions are costing the judicial branch. I deeply regret all of the time and effort that my shortcomings have caused you to endure. I erred, and I should have known better. You have the right to expect more from me. You have the right to expect and demand more from your magistrates. I do not lack for confidence in my abilities for the service that I provide to the First Judicial District. I believe I'm a very good magistrate and that you would normally be extremely proud of my actions with the general public, with the prosecutors and defense counsel that appear before me, pro se litigants, court attendants, clerks, and all of my fellow judicial officers. That is one reason why my actions trouble me. I try to hold myself out to the highest standards, and the fact that I have not even met the basic standards of my job responsibilities is very painful. I know I'm human, but I never thought I would be here today, the subject of your concern. I've always envisioned myself before you earning praises and acclaim, and obviously my actions do not warrant praise and acclaim, and I am very disappointed for those actions that have led me here today under these circumstances. I know you've read my brief and that of the AG's. There's no doubt as to what happened 26 months ago. I'd requested the 10 files from the clerk and told them exactly what my purpose was to put them on the bench for a 1:30 hearing that I had. I picked those files up. Contrary to the AG's belief, there's no evidence in the record that I was personally financially benefiting from those actions. At no time was I ever asked whether or not I was being compensated. Both the commission and the AG just assumed that I was being paid for my services, when in reality I was providing those services pro bono to a domestic abuse client. That doesn't give me the right to act in an unethical manner, just as I cannot act zealously in an unethical manner as well. 2 of those files had been expunged, but I did not use any judicial resources to find out about them. They were disclosed in discovery answers, and on the case that was used, I had obtained a copy of that complaint the day after it was filed with the district court. I was representing the victim in that matter in the contested custody case, and obviously it's a document that I need to have and to be aware of in zealously representing the victim. I even assisted my client in drafting a letter on behalf of the victim to the court so that she could get a deferred judgment. Just somewhat ironic that after I assisted my client in that letter that I would be back here as a result of that same deferred judgment. I was simply unaware of the clerk's policy concerning files to be delivered to the district court. I erroneously thought that it would not be a violation of that policy merely to deliver the files and put them on the bench for the district court judge. But the clerk testified at that hearing that a non-magistrate would not be permitted to pick up those files and put them on the bench. A non-magistrate attorney would have been required to have the clerk take all 10 files up to or to take those 2 files. They'd have given me the other 8 files, and they would have had to personally put them on the courtroom bench. And I certainly don't want this case, however it turns out, to ever be cited for the rest of eternity as determining issues between 609A impeachment evidence and the 402 relevancy questions. But I do think the AG's brief was wrong on that. I think it's strong public policy. We don't want to discourage victims from contacting the police. If we were to make anything in that deferred judgment file to be inadmissible, then you would never have your clients contact the police, because it might result in charges which are then deferred, and which then you could not, then the district court judge could not consider in any future hearings, custody determinations or anything else like that. So I do think that the code statutorily defines the fact that the police were called, the fact that arrests happened, and that a person pled, guess it's the pleading guilty part isn't in the code, but in 598.41 are the ones that specifically provide that this is relevant evidence that the court should consider.
Couldn't you present that evidence without getting the files from the clerk's office?
Absolutely. I could have had my client testify to that. I could have had my client was aware of the fact that she had pled guilty to that. I could have had the client testified that he wrote a letter, that I helped him draft a letter. Again, I don't know if stupidity is an aggravating or a mitigating factor, but there were several really stupid things that I did, and I deeply regret those.
Sort of in a tough position, though, because you practice law and have this magistrate hat, and I guess the clerk probably was unaware, as I understand it, what hat you were wearing at the time you came down?
I gave the clerk, I gave Rod, a piece of paper with 10 files on it. And I said, I want these to give to a judge, you know, and put them on the bench. I'm not gonna question Rod as to whether or not he knew I was a magistrate. I might have told him that I got a custody hearing. I might not have. I don't expect him to second guess me. You know, those are the things I tried to take into account. It's not that, certainly not that I was pulling my weight around and saying, get me these files and everything. I was trying to actually assist them by not having them go up there and
For
put it on
example,
the
I had an
bench.
old client call me just last week, and I had to check something at the Polk County Courthouse. So I went down there and didn't get any special treatment, asked someone to check a file, and I got a phone call back. And then they said, oh, this is Justice Wiggins. I says, this isn't Justice Wiggins. I'm just doing an inquiry, and I don't want any special treatment. I mean, don't you think when you have this blurry line, you should at least, you know, tell the clerk that this is my private practice, not my official practice?
Yes, I certainly should have. May I have done that? Yes. I'm not positive that I did that. Again, 26 months ago. I don't remember the things exactly that I did. Yes, and in the future, I've been enlightened. I can be certain to do that. Yes, I admit there was a mistake made. I was probably even, well, again, the proper way would have been to say, look, you can give me these 8 files, these 2 other files, would you please put them on the bench for the court, for the judge? And I think that would have been fine. I don't think I'd have had possession of them. The next part was...
Could have said, I'm here on a private case. I need these 10 files for my case. How do I do it? And let the clerk tell you, well, you could have 8 and I'll take 2, rather than saying, just get me these files, you know?
That might be putting a little too much on the clerk for them to make it. I think I'm to know my limits. I'm to know what the right way to do it is. I think when any judicial officer goes to a clerk, they're going to think what he says goes, okay? I think the proper way would have been for me to know, and I'm not blaming the clerk, and I don't even think it would be wise for me to ask them how to do my job, okay?
Magistrate Sevcik, maybe you could get into, you know, not the minutia of that, but what's your position about the state's position that we really don't have the ability to do now more of a private versus a public admonition?
Well, obviously I disagree. I don't have any case law, any authority. I did note the decision that came out in Ray John Doe very recently, where the attorney was given a private reprimand by the court. I think this court has the sole duty to discipline their judges however they see fit. I don't think that the code limits that. Yes, there has been some public matters go on, but the court can issue a ruling like it did before. I recall the case where the commissioners and the I think it was just the Attorney Disciplinary Commission, where they had stipulated to certain facts that were done wrong and everything, and they said, no, look, this is our job. We can't delegate this job to the commission and to the councils. We have to make certain that there's a factual basis for these things, and as a matter of fact, in these, we find that there is not. And there was certainly case law that says, initially, maybe somewhat dated, where they didn't even know if they could go ahead and give a recommendation to the court. So if they didn't even know they were giving a recommendation to the court, the code hasn't changed since that case, and the court said, yes, we appreciate, and it is proper for you to go ahead and make a recommendation. I don't think that case stands for the proposition that it's mandatory and binding on it, and to the extent that the only thing you can do is issue a public reprimand or a public admonishment or dismissal, I guess that's the backdoor way out of it, is that the court could always dismiss it if they feel that it wasn't a substantial violation of the rules, because the court is required to find that there was not only a violation of the rules, which I readily admit, which I admitted to Judge Harris, to the commission. The disciplinary, there was an issue, much of the state's brief was talked about whether this was done in my judicial capacity. And certainly, when I was there and I asked Judge Harris for the file, I approached the bench, got it from him, asked to approach the witness, granted permission, and asked her to answer those two questions. What is this document entitled? Is that your name on it? There's no doubt that I was acting as a private attorney at that time. The matter was reported to the Attorney Disciplinary Commission, and they issued a private admonition and a private reprimand on my actions that I took as an attorney. And I've heard from judicial officers that the commission often tells the judge when there's a criminal violation involved with it, hey, look, the cat's already out of the bag. It's been in all the papers. You know, how can we make this, it can't be any worse than what it has been. And to the extent that the inverse of that is true, and I'm not contending that you are bound by the findings of the Attorney Disciplinary Commission, but to the extent that is true, that the inverse is true, it does little good for the Attorney Disciplinary Commission to give me a private reprimand if this court's going to go ahead and give me a public reprimand. It'll still be public, obviously. But I would contend that this commission can certainly issue a private admonition. Things are out there. They don't have to be any more public. Like I said, I was very pleased not to appear here last night with everybody in the courtroom. So again, I erred. I made a mistake. I think those types of mistakes, a good faith mistake of just having the clerk give me the two files and putting them on Judge Harris's bench, is the type of actions and conduct that would warrant a private admonition, and that's what I asked this court to do.
Which, you stated you readily admit violating a rule, but which one?
Well, I admit violating parts of several of them, Your Honor. I admit that I violated the clerk's policy, and as a result of that, there was certain confidential information. Well, that would go to the fact of getting the file out and using that confidential information and using that. So I've certainly violated 51, 30. I don't have them right in front of me, Your Honor. I apologize for that. My actions were wrong. They were a mistake. You deserve better, and I am very sorry for my actions. My time is out and over. Thank you.
Thank you as well. Mr. Cmelik.
May it please the court, I just have a couple of short comments to make. And I don't want to suggest, and I hope I didn't suggest in my brief, that it's only financial gain that's covered by the rule. The rule says that to gain a personal or economic advantage. You certainly are gaining a personal advantage as a lawyer when you, act on behalf of your client to win a case. So I don't think that, I'm not sure the commission even suggested that it had to be financial gain. There certainly wasn't any record presented about what kind of money was paid in this particular instance. It was about the advantage that was gained using the information. I would submit that attorneys are different than judges. What might be an appropriate discipline for an attorney is not necessarily appropriate for a judge. We're serving different purposes here, and we have different concerns. And finally, I want to just go back to this idea of public admonishment or public reprimand. We're not delegating anything to the commission from the court. The statute defines the roles that the commission plays and that the court plays. It says the commission shall dismiss if warrantless, or if substantiated but not important, issue a letter of caution, reading the rule with it. But once it becomes public, it's public. And I think that it doesn't serve any practical purpose to call a public admonishment private. So I do ask that you adopt the recommendation. Thank you.
Thank you as well. The case is then submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.